If you're going through a divorce or anticipate that you will be in the near future, then you're facing what is likely to be one of the most difficult transitions of your life. You're probably also facing a lot of uncertainty, which is why we've created this video series outlining the divorce process in Connecticut. While I hope that this series is useful in educating you about the process, I'd still highly recommend that you consult with an experienced divorce attorney to discuss the specifics of your case. The first step is to draft a divorce paperwork and have it served on your spouse by a marshal. After your spouse has been served, the divorce paperwork is then filed with the court and your case is assigned a docket number. Now, for the first 3 months after the case has been filed, there are no scheduled court appearances, and during this period, you and your spouse will exchange financial affidavits, which is a list of income, assets, and liabilities, and you'll also exchange certain financial documents to support those financial affidavits. Now, the exception to the 3-month waiting period is if either you or your spouse file what are known as Pendente Lite motions. Pendente Lite is a Latin term meaning during litigation, and these motions are necessary in order to have court orders put in place while your divorce is pending. Now, the most common Pendente Lite motions are a Pendente Lite motion for custody and visitation, which is a motion to have a parenting plan put in place while your divorce is pending. Then there's a Pendente Lite motion for alimony, child support, or contribution towards household expenses if either you or your spouse require financial support while your divorce is pending. Or there's also a Pendente Lite motion for exclusive use of the home if either you or your spouse are seeking to have the other removed from the home while your divorce is pending. Once the Pendente Lite motions have been resolved and you've exchanged all necessary financial documents, you and your spouse will schedule what is known as a family relations pretrial. During this pretrial, you and your spouse or your attorneys will sit down with a family relations worker who is an employee of the state of Connecticut and will act as a neutral third party. The family relations worker will try to help you and your spouse reach an agreement on custody, child support, alimony, division of assets and debts, and any other issues that need to be resolved in your case. If you're able to reach an agreement at the family relations pretrial, you'll draft a final divorce agreement, appear in front of a judge, and finalize your divorce. Now, if you're unable to reach an agreement at the family relations pretrial, the next step will be to schedule what is known as a special master's pretrial. Now, a special master's pretrial will only take place if both you and your spouse are each represented by attorneys. It's similar to a family relations pretrial, except the neutral parties in this situation are a male and a female volunteer attorney, each of whom have significant family law experience. At the pretrial, the attorneys for you and your spouse will go in, they'll make their pitch about what they think should happen in the case, and the volunteer attorneys will make a recommendation as to what they think is a fair resolution to the case. Now, if your attorneys reach an agreement at this stage, then they'll draft a divorce agreement, you'll appear in front of the judge, and your divorce will be finalized. If they're unable to reach an agreement, then the next step is to schedule what's known as a judicial pretrial. A judicial pretrial will also only take place if both you and your spouse are represented by attorneys. It's similar to the previously mentioned pretrials, except the neutral party in this situation is a judge. If you're able to reach an agreement at the judicial pretrial, then the divorce will be finalized. But if you're unable to reach an agreement, then the final step is to schedule a trial. At trial, both you and your spouse will appear in open court in front of a different judge than the one who handled your judicial pretrial. Both you and your spouse will present testimony and other evidence as to what you think should happen with regard to custody, child support, alimony, division of assets and debts, and any other issues relating to your case. At the end of this testimony, you'll present closing arguments, after which the judge will issue a decision which is binding. Generally speaking, the divorce process can take anywhere from about 3 months if your case settles during the family relations pretrial stage, up to about 1 year if your case goes to trial. Every case is different, however, the majority of cases settle during these initial pretrial stages. For more detailed information on how the divorce process works, please watch the other videos in this series. And if you have any specific questions, don't hesitate to call our office at the phone number below. I wish you the best of luck in navigating this very difficult transition in your life.